So this is a brief summary of the Week 7 lecture material, and I'll start now by saying legal procedure and legal process both sounds really boring and by and large is in fact really boring. However, it is really important, and there's lots of different ways that manifests inside our legal system. Now, first of all, our system is what's known as adversarial, a bit like the US, Canada. It derives from the UK. The two sides bring evidence to the court. The judge essentially doesn't get off her or his seat. Other countries, such as France, have an inquisitorial system where the judge is active in the court process. The two different types of matters in our system are civil and criminal. Civil matters are disputes between citizens. Criminal matters are usually actions taken by the state against a citizen, usually to deter or punish for certain types of behaviour. Now, some important features of civil procedure, first of all, is making people aware that they're being sued. These are the rules for service, and it's a very structured system, and decisions can be overturned where those rules aren't followed. Another is the structured timeframes. Actions have to be managed and run and flow continuously. If you take too long, you run out of time for certain stages in that. Also, particular documents have to be created and formed and pleaded in certain ways so that the other side can really understand what it is you're claiming from them. There are systems of discovery so that each side can access the other's evidence to try and avoid this sort of trial by ambush. And there's what's known as limitations on actions. That is generally 6 years. If you don't bring that matter to the court, you lose the right to sue that person and try and seek some sort of compensation. Now, in trials, each side collects their evidence and are given the opportunity to talk about that and explain what witnesses they're going to call. And then those witnesses are examined. In other words, put on the stand, asked questions by the side that called them, and then the other side gets the opportunity to cross-examine them. Now, a very structured area of this are the rules of evidence themselves. Evidence must be relevant in order to be put before the court. And there are lots of other rules to do with evidence, and they're really fundamentally about fairness. When somebody says something, they can't assert particular facts. Only the person who originally saw that particular matter, that's the hearsay rule. Similarly, if the accused in a criminal matter has had similar charges before, those can't be mentioned to the jury. And there's this right to not incriminate yourself when giving evidence. Now, for both civil and criminal matters, there is a burden of proof. Each of these types of actions requires a series of elements that all of which must be proved, and the side bringing the action must prove those. If they can't prove all of the elements, the action cannot succeed. Now, the level of proof, what we call the standard proof required for civil matters, is that each element has to be proved on balance of probabilities, whereas for criminal matters, each element must be proved beyond reasonable doubt. And for certain types of matters, such as possession of drugs and so on, the court can actually reverse the onus. In other words, require the accused to prove certain standards and aspects to it. Now, another procedural thing we have here in Queensland is what's known as a committal hearing. That is when the prosecution, usually the police, presents a small amount of evidence to the court just to prove that this matter can actually go to trial. And if the magistrate is happy with that, then they select the particular court that the matter is to be heard, and be it the District Supreme or the Magistrates Court itself. Other features of our legal system include a jury, in other words, a group of citizens who will determine matters of fact throughout your trial. Also, we accept that in our legal system, the poor, impoverished and disabled can need some form of additional help, so that we have systems in order to offset that inherent disadvantage. In terms of legal representation, that is in the form of community legal services. Another important feature is the concept of due process. This is this idea that our courts and the process of making decisions must be open, it must be transparent, free from bias, and each person has a right to adduce evidence to their defence. Also, another area in our legal system is what's known as administrative law, whereby systems of what's called judicial review and merits review can be used by the citizen in order to hold the executive arm of government accountable. Where the executive makes a decision, if it's outside their power, or they haven't done it following the appropriate due process, or natural justice or procedural fairness, that decision can be overturned by the courts. Finally, we have systems in place in our legal system to really try to avoid people going to court. We call these ADR, alternate dispute resolution mechanisms. Some examples of that are negotiation, mediation, arbitration, and expert appraisal of cases. Fundamentally, though, everything you've heard in this very, very brief synopsis is about justice and fairness, and in particular, a lot of the benefits go towards the accused in criminal matters. Really, that's just about upholding the rights of the citizen in order to live in a free society.